Yes.
Yeah.
Sorry. Nope, you're fine.
That's no landmines in the top of those.
All right. Let's go ahead and call the Cascade Planning Commission meeting to order. We get a roll call?
Yes, Commissioner Tucker,
Here.
Commissioner Spence,
Here.
Commissioner Carpenter,
Present.
Chair Wheeler,
Here.
Commissioner Stahl,
Here.
Commissioner Eisenberger,
Here.
and then Commissioner Perkins. I think he's here. Commissioner Perkins?
Oops. Hi, can you hear me?
Yes.
Hi.
Okay, we got everybody today. Excellent. All right, first item of business is our approval of the August 2025 meeting minutes that are in our packets. We'll need a motion and a second on that one. Somebody's ready?
So moved.
Second.
All right, we got a motion, we got a second. Any reason to discuss?
Nope,
All right, all those in favor, please raise your right hand.
my hands up.
Motion carries. Perfect. Commission business here. We got a couple new things on here. First one is city planning updates, and then we're gonna get into land use 101.
I'm doing the city planning update.
All right, perfect.
Yes.
Let's hear it. We're
Okay.
excited.
And then Evelyn's gonna start my presentation. Very short and sweet. Okay. You can go ahead and go to the next slide. Okay, so we started construction on the wastewater treatment plant over there in what used to be Portal Park. In August, this is expected to take 27 months. We had a slight little hiccup, so we found an old bottle on the site from the 1800s, which is an archaeological resource. And so we had to establish a 25-foot barrier around that bottle and then turn it into the State Historical Preservation Office in order to review it to see if it has any historical relevancy. The report says it's most likely garbage. So I'm paraphrasing there, but so in that one section where they found that bottle where we can't do any work for a little bit, but that's not holding up the project. It's actually kind of in a good area. We can still continue on with the rest of the project. So next, the water treatment plant. So we will be publishing an RFP, which is a request for proposals for the MBR equipment at the end of September or early October. The city's engineers are currently doing kind of the initial engineering to look at what types of equipment. We're going to look at the MBR, but there's a lot of different brands. So we'll publish that, get bids back, order the equipment, because that has a very long lead time. And we want to be starting work on that next year, ideally like next fall, winter, so that it's done in the slow season for water. And while that is published concurrently with that, we'll be publishing an RFP for the engineering to do the upgrade for the water treatment plant. But we have already upgraded the raw water pump and the pipe sizing in order to prepare for this so that the new upgrades will allow us to process more water and make more clean water up to pretty darn close to our water rights. Okay. River Mill Road, we had received about 800, it's like 790 something thousand dollar grant for the traffic circle construction at River Mill and Eagle Creek intersection. Curran McLeod, which is the city's engineer, is currently engineering. And then the county also received approval to lower the speed on River Mill. So we should expect to see that decrease to 30 miles per hour here in the next few weeks, because that is a county road, not.
Is that all the way across towards the rock pit too, or just on the in between the old highway and Eagle Creek?
I don't know the exact section of it. I'd have to look at them. Yeah, sorry. Okay, next. We applied for a planning grant to update the parks master plan. I know that you guys were interested in that. We'll find out if we receive this grant. The board is meeting today, so we'll find out tomorrow if we receive the grant. I have very good feelings. I have very, very good feelings. So we are planning on issuing an RFP for a firm in order to do that work in November.
That's awesome.
Yeah. And then Wade Creek Park Trails. After we built the park, we heard a lot of feedback from the community that those gravel trails aren't really accessible either to people who are using mobility devices or even just children in strollers. And so we're paving those trails, and that begins. It's supposed to begin either today or tomorrow. But it should be completed by November 15th. And we were able to, because that bid came in pretty low, we were able to add in a few speed humps to the paving contract. So we'll put speed humps on Sweetwater, Pierce, and Hillway. And that is the end of my update. Any questions?
I have a question on the water side of things.
Yes.
Do you guys know of any jurisdictions on this side of the state that have an irrigation district?
I don't know of any. No, not off the top of my head.
And the only reason I ask, like, I know Hermiston has one,
Mm-hmm.
and so they pull just raw water out and everybody's watering their yard with the irrigation water, not
Yeah.
the treated, wonderful Clackamas River water. And so if that would help our capacity issue in long term, as far as the amount of clean water that we produce and use goes up dramatically during the summer because everybody's watering their yard with it.
Yeah, it does. So the capacity issue is going to be our water rights, and whether we're using that water for irrigation or we're using that water for treatment, we only have so many water rights. It's 2.6 MGD. So at some point in the near future, depending on growth, we're going to reach the capacity of our water rights. And even if we had some kind of irrigation district where we repiped the entire town in order to have a separate pipe for irrigation, that wouldn't impact our water rights. So potentially you could look at using the treated effluent for irrigating.
That's kind of where I was thinking.
Yeah, that's another option, is using that. But I think that also requires a really large infrastructure improvement because you're going to have to pipe separate pipes for the treated effluent.
It'd be interesting to know the cost difference between all of the ongoing upgrades of putting super clean water on grass versus
Yeah.
that just pumping it straight out of the plant. And I know there's probably a stigma with putting effluent out of the brand new wastewater treatment plant in your yard, but if it's quote unquote clean,
Yeah.
it makes a lot of sense.
Yeah. I mean, one other option we can look at, and the state is copacetic, we'll say, is pumping the treated effluent back into the water plant for treatment and using it for drinking water, clean water eventually. And they do that in other parts of the country and world. So
Since we're talking about water, the cost of this water upgrade, are the original projections still pretty applicable right now, or are the numbers shifting? Have we seen any movement one way or the
I
other?
haven't, no, I haven't. I mean, because we just updated the water master plan just like 6 months ago is when they approved it.
Yeah.
So we haven't seen any changes yet. They're doing the initial engineering. And if we see anything, I think what we'll see changes potentially is when we get those RFPs back on the process equipment, because that's going to
Sure.
be probably the largest single piece of equipment is the membranes.
When you mention water rights, is that just what we pull out of the river? Or does that include our wells? If
We don't
had-
have any wells.
Well, if we had wells in it, would it be separate from that? If-
It would be separate from that.
Okay,
Yeah.
So that's probably where it'd have to go if we reach that limit, maybe, or something.
Potentially, but we have people in the neighboring, around the city who are joining the city because their wells have run dry.
Hmm, okay.
So the water table is not great. Yeah.
Is that an option though?
To join this,
No,
It-
to drill wells?
it is an option to drill wells, potentially. I mean, we'd have to go to Water Resources and apply for water rights, even if we're drilling a well.
Any other questions? Terry, you got any questions?
No, I love the update though. Thank you so much.
You're welcome.
Thanks, Lana. All right, moving right along, land use 101. Who gets this one?
I think I do.
All right.
So I want to introduce myself. My name is Carrie Richter. I am your interim contract city attorney. I came in after the passing of Peter Watts, your longtime city attorney. I have been practicing law as a municipal lawyer for the last 28 years. I currently represent many other cities in Oregon, your neighbor, Oregon City, City of Island City over by Pendleton,
Yeah.
City of River Grove, City of Cannon Beach, City of Nehalem, City of Wheeler, City of Sherwood on occasion. Right now, we're representing Washington County on land use matters. So I done a lot of municipal law, and I am excited about the opportunity to come and do a little land use training. I do these land use trainings annually for many of my cities, both at city councils and planning commissions. I find it really a great opportunity for me to sort of, even folks who've done this for a long time, hopefully get something out of these presentations, not just those that are brand new. This is also your opportunity to ask me questions. I'm also a land use lawyer, so I do a lot of my work is land use. So I've done cases at the Land Use Board of Appeals and the Court of Appeals and the Oregon Supreme Court. So I know a fair bit about land use in Oregon too. So the purpose of this is I can't cover all of land use planning in an hour, and I'm going to keep this to an hour because I think it's fair to you all. And I think if there are questions or there are areas that you're particularly interested, I mean, we can talk to the city about coming back and doing a follow-up. I have been known to do land use 102 and 103 and 104 to those who are interested in particular areas. So with that framework, feel free to interrupt me and ask questions as we go along. I think you've got my PowerPoint slides, or you haven't yet. If you don't have them, we will make them available. The purpose of this is to talk about your role as planning commissioners in the process of what you do for the city. Talk about public records and public meetings law a little bit, and then talk about some of the recent bills that have been passed by the Oregon legislature that will change how cities provide land use reviews. So first slide, Oregon's land use planning framework is based on it's a building block type of program where rather than the city of Estacada applying certain statewide legislation directly, usually the city implements state statute and administrative obligations through its adopted comprehensive plan and comprehensive plan map, Estacada municipal code, and Estacada zoning map. That's why when you hold a hearing, you don't pull out the US Constitution generally. You don't pull out the Oregon revised statutes generally. That's because the city has implemented constitutional obligations, statewide obligations into its regulations. But just because they're in the regulations, in the adopted regulations, doesn't mean they don't also apply. So things like Fifth Amendment takings requirements, religious protections, free speech, Fair Housing Act, Americans with Disabilities Act, these are all principles that have to guide your decision-making, but mostly that is done through application of the municipal code. You should be aware that at the state level, in addition to the revised statutes, which are passed by the Oregon legislature, there is an administrative agency called the Land Conservation and Development Commission. That is a board in Salem that is charged with implementing the state land use program. And they do that through the adoption of administrative rules. One selection of those administrative rules, and the most important, are the 19 statewide land use goals those statewide land use goals, provide for general values that are to guide our land use program. For example, goal 3 is farmland. For example, goal 10 is housing. For example, goal 11 is public facilities. Goal 14 is the urban growth boundary. What those do is they provide general principles that then the city has to implement through its own means and substantive standards. So the city has done that through its comprehensive plan and municipal code. And because the city has done that and the Land Conservation and Development Commission has blessed that accomplishment, the city, when it makes land use decisions, most cases does not have to apply the statewide land use goals. They fall out. In other words, because the city's code is acknowledged. But when the city amends its comprehensive plan, does a zone change, or alters its regulations in some way, the statewide land use goals do apply. So in a staff report, you will see the statewide goals apply when we're doing code amendments, but they don't apply when you're reviewing an application for a land division or a conditional use permit, because the city's code has been what we call acknowledged to comply with the statewide land use goals. Questions about that? Okay, next slide, decision-making. There are two different types. There are two different types of decisions that come before the Planning Commission for consideration. There are long-range planning decisions, and then there are quasi-judicial development review application type of review. Long-range planning is often called legislative. You'll hear it called legislative, and that is where most often these are city-initiated proposals. They involve amendments to regulations, and what makes them distinguishable is that they apply to a large area. They don't affect just one property. They would come before you, for example, like the sign code that Alan's working on that you're going to talk about today. That's a legislative decision. It's a political decision. Whether you do it, what way you do it, political question, right? So you will make a recommendation to the city council, and then the city council will take final action. Because legislative decision-making is political, it is not subject to strict limitations on evidence and ex parte contacts. Ex parte contacts are conversations that you as a decision maker may have with people outside of the public hearing process. And the reason we want to control ex parte contacts is we want the participants in the process to know what conversations you've had, what they want to, we need to control the evidence, right? And if people in the participants don't know these ex parte contacts, they can't respond to them. So when we're doing legislative decision-making, have all the conversations you want. It's supposed to be a political decision. So you're supposed to talk to the constituents and hear what they want and implement that. The other type of decision, quasi-judicial decision-making, is where you have an applicant, private property owner, most often filing an application to develop their land. And because this has to do with their private property rights, we have to provide additional due process to that review. And that additional due process requires that we have an unbiased decision maker. And we have a decision maker who makes a decision based on the materials that are compiled in the record during the proceeding. So that's why we have to file a formal quasi-judicial procedure. I mean, when you think about this, you are sitting like a judge in a criminal trial, for example. The judge does not know the defendant, doesn't know the prosecutor, doesn't live in the neighborhood. It's a little different in your case. You do live in the neighborhood many times. And so the law acknowledges that there is a internal struggle between or conflict between this. You represent a small community. You know everyone. You know all of the land. You know what everyone's doing. So to say that you are completely unbiased isn't likely. But the law tries to protect the process by ensuring that we can acknowledge the bias and communicate about it to ensure as fair a process as we can. And I'll talk a little bit further about that. As we move along, in quasi judicial decisions, generally the planning commission is the final decision maker in these kinds of cases unless the decision is appealed to the city council. So an applicant gets the final decision from you. Okay, the review categories, move on, you can move next slide. Review categories in Estacada there are 3 types. There are administrative decisions. Administrative decisions are decisions you don't see. This is a building permit. I come in for a building permit and when I submit my plans, it goes to Alan. Alan reviews to make sure that the development setbacks are satisfied, the heights are satisfied, the transparency requirements are satisfied, whatever clear and objective standards are necessary for me to get a building permit, and he signs the permit and then that's it. There is no notice, there is no right to appeal. It's an administrative decision. So building permits, lot line adjustments, middle housing land divisions, these are all ministerial or administrative decisions. The types of decisions that you see are, as I said, quasi judicial decisions. These are land divisions, design reviews within the downtown zone, some of them, and conditional uses, variances, and some annexations. The way the design review in the downtown zone works, if it's an exterior alteration or addition, it's a staff decision with an appealable right to the planning commission. If it's new construction, it goes to the planning commission or a design committee with appeal rights to the city council. So as I mentioned, next slide, as I mentioned, the reason why we have a quasi-judicial process is to ensure predictability and a level playing field for all participants. And there are some state laws that set the floor for what the city has to do when it's reviewing quasi-judicial applications. It has to make a decision within 120 days, and that 120 days starts the day that the application is deemed complete. So I file an application for a conditional use permit. Alan reviews the Alan has 30 days to review the application to deem it complete, which means he goes and checks the boxes to say, yes, there is a traffic study. Yes, there is a site plan. Yes, there is a survey. It's not, Alan is not saying that the criteria for getting a conditional use permit are satisfied, but rather the materials necessary to process the application have been filed. Assuming that the application is complete, Alan issues a letter that says your application has been deemed complete, and that is the date that 120-day period starts. So, and that 120-day period is for the all of the land use decisions necessary at the local level. So that's all the way through to city council. So if the Estacada Planning Commission needs 3 hearings to review a conditional use permit, that puts the city council's back up against the wall to process an appeal. So when we have situations where we have applicants who want continuances, we gotta work with Alan to make sure we don't get our back against the wall on this 120-day limit. If you're interested, what happens if the city does not meet the 120-day deadline? An applicant has a right to go to circuit court and ask a judge to order the application approved. And in that process, the court can order the city to pay the applicant's attorney fees. So it not only is an automatic approval, potentially it's an attorney fee recovery too. So that's not a situation we want to get into. Questions about that?
One question on the next
Yeah.
portion there, the 100 feet, mailing notice to the property owners, 100 feet. Who dictates that?
So the state law minimum is 100 feet. Your code is 100 feet. You could make it more if you wanted to.
I'll just chime in here and say that our comprehensive plan requires 300 feet for zone changes, but it's not been implemented in the code yet. But that is something that we would look at with the code audits or the code amendments.
And that's across all zones, right? Within the city?
With the zone, yeah, zone change would just be any zone change application would be noticed of 300 feet within the property.
It just seems really short for a 100 by 100 lot. I mean, you're talking to one neighbor. On each side. presume.
100 is quite small. In most of the cities I represent, it's 300 or 400 or 500 feet.
Thank you.
So we have to give notice 20 days in advance. We have to provide a staff report available 7 days in advance of a hearing. We have to provide a public hearing. At the opening, as part of the opening presentation, as you may already know, there is a little script that the chair reads and it's riveting. And it just engages people immediately with the process, I found. But it's required by state law. The city doesn't have a choice. The city could animate it. I've always wanted somebody to put together like a little like airline stewardess emergency exit kind of video, but nobody's got that kind of spare time other than, me in the middle of the night thinking about it.
I had the same thought about that. I said, why don't we just have a thing? We just push the button and it plays and we're done with it.
Yeah, yeah. But what's important about, there are some key components about that I want to highlight. First, there are instructions that, the submittal of evidence needs to be put into the record, which means if I come to the meeting with a PowerPoint presentation, that presentation needs to be put in the record. If I come with a poster board, I need to leave the poster board with the city so that it's part of the record, right? Because the city has an obligation to keep all of the written materials and all the electronic materials in one place so that if the case gets appealed to city council, we have the record. If the case goes on to the Land Use Board of Appeals, we have the record. That's the city's obligation. So folks, we need to make sure that if folks, point to their shirt in the hearing, theoretically, they need to leave their shirt with the city. So that's part of this, these instructions. Testimony needs to be directed to the criteria. This is something that's really hard for people to understand, and it's really important. If I am an applicant representing and I want to develop a new school, I might bring in all the students who love my school or will benefit from my school. The criterion is never whether a school is a good idea. Right? The criterion has to do with development and design standards about a building and the demands of that building, the sewer pipes and the water pipes and the roads, and not whether or not a school is a good idea or a bad idea. And so a lot of that testimony can be received, but it doesn't directly relate to the applicable approval criteria, right? This Planning Commission's only job is to apply the standards that are adopted in the code. And those standards are things like, is the proposal compatible with the surroundings? As I said, is the infrastructure adequate? That does not require a judgment about the good or bad nature of this particular use. So, it's a good, when the opening comments explain that the Planning Commission can only approve or deny an application based on the adopted standards, and that the testimony needs to be directed to those standards, that can sometimes help people understand exactly, the Planning Commission can't deny use because it doesn't like it. That's not within its charge.
Oh, question on that. Can the
Yeah.
city council deny it based on that?
No. No, because the criteria are the only thing that can be the basis of approval or denial.
Can the city council go outside of the scope of what we're looking at, though?
No,
Not at all. Oops, I'm sorry.
no.
Okay.
They're reviewing the same criteria.
Okay.
Where you have discretion means policy judgment, is with respect to criteria that require that judgment. So for example, is the proposed use compatible with the surroundings? The planning commission has to decide what are the components of this use? It's not just a building. It has people that enter and exit and circulate in a certain way. It demands traffic. It demands infrastructure. It is not just a building. Okay, so you've got to decide what is the nature of the use. Then you've got to decide what are the surroundings. Are the surroundings right next door? Are they across the street? Are they down the street? How big is that surrounding? Those kinds of discretionary interpretations the planning commission will make, and then the city council can either agree with those or they can make their own. But the criterion is still compatibility with the surrounding use. Make sense? Other questions about that? Okay, raise it or waive it. This is a really important principle in land use. It's that if a person wants to appeal an issue, they have to have raised it below. And so if you want to challenge a decision at the Land Use Board of Appeals, you have to show that you put the city on notice of the issue. And so this is a slow narrowing of the issues so that the city doesn't have to worry about revisiting settled questions at every phase. And the way the esticated procedures are set up, the planning commission has an what we call de novo hearing. That means like new. That means any evidence can come in. Anybody can bring any piece of paper. They can testify about anything at the hearing. The planning commission makes a decision. If that decision gets appealed to the city council can decide whether or not it wants to have another de novo hearing. That means allow all new evidence, all new issues, bring any issue you want. Or the city council can hold an on the record hearing, which means they don't take new evidence. And if they don't take new evidence, they're just reviewing the evidence that you already got. And so raise it or waive it is really important, that the public understands that their only opportunity to present evidence and make arguments might be before you. They can't wait in the weeds until the appeal hearing at the city council and come in with the land use lawyer who's got all these new issues. If you have an issue, you got to bring it to the planning commission at the first review. That's what raise it or waive it means. You have to raise constitutional issues, and you have a right to an impartial tribunal. You probably already know this, but at the very initial hearing, any party has a right to a continuance, and that request can come from an applicant or a participant or any other participant. And if that request is made, it has to be granted. The initial hearing, just the first one. That can take the form of a continued hearing to the next planning commission meeting that is scheduled, or it can allow for written submittals. It's a little complicated, but the process is 7 days for anyone to participate, 7 days for anyone to respond. Then the applicant gets a final 7 days. Usually local governments don't use that post-hearing written submittal period because that takes longer than your next hearing. So it's just, it doesn't save any time.
Does that affect the 120-day decision limit, or does that get,
It does not extend the 120-day limit. That initial continuance does not extend it. The applicant can always extend it, but only the applicant can extend it.
so if the applicant chooses to a continuation, we're still bound by the 120 days?
Yes. But oftentimes what a planning commission might do is the applicant requests a continuance, and the city, although the city has to grant it, the city might say, well, will you extend the 120 days by 30-day obligation by 30 days? Doesn't hurt to ask. they'll say yes or no. If they say yes, then you got another 30 days. That pressure becomes higher as the time passes. And they've got a second continuance request. Let's say they come back and say, you know, we really want to put together a traffic study and we need time to do that. Well, we'd love to give you that time, but you have to extend the 120-day clock in advance. And oftentimes I worked with staff to vet this before the meeting, so it's not on the fly. Okay, next slide. I've got a slide here that talks about roles and responsibilities. I'm not going to go through it in detail, but what's important about this slide is that the applicant bears the burden of proof in a land use proceeding. That means they have the burden to produce the evidence to prove that the standard is satisfied. That means they have to provide the traffic study. It is not an opponent's job to go to a traffic study to show that the applicant's proposal is lacking. You see the difference? The applicant has to produce the evidence. And it is also not the obligation of the planning commission to design the project for the applicant. It is the applicant's job. And if the applicant does not do that, then the application has to be denied or conditioned in some way to assure that the criteria are satisfied. So that's another sort of principle of land use law that I think helps explain a lot of the things that come out of that. But so next slide, right to an impartial tribunal. We've talked a little bit about this. Ex parte, so decisions have to be based on testimony and evidence that's part of the record. So you're in the grocery store and a person comes up to you and says, you know, this grocery store conditional use you've got before you, I really think you should deny it because it's really going to generate a lot of traffic. And you're in the grocery store, right? This really is a bad idea. That is an ex parte contact, right? That is someone trying to share with you evidence or their feelings about an application outside of the hearing process. And what do you do about that? Well, at the time, you can have the conversation with those people if you want to, but you have an obligation at the next public hearing where the matter is continued to disclose that contact, the substance of that contact. And the chair will call if there's any ex parte contacts, and that's your opportunity to say, on September 15th, I ran into a citizen at the grocery store and they proceeded to tell me they wanted to talk to me about the project. And then you say, and I told them to come to the hearing on this day and to bring their concerns there. Right? Because we want participation. We just want it to happen in the right forum. It's also important to know with ex parte contacts that ex parte contacts include newspaper articles or social media that you may come into contact with while an application is pending before you. And when that happens, the best thing to do is to forward the substance of that material to planning staff, and they will just put it in the record. Right? Then the whole idea is we're putting it in the record so the people know it's there so they have an opportunity to respond to it. Okay. A decision maker has to be free of bias. Actual bias exists when the decision was the product of positive or negative bias rather than an independent review of the facts and law, right? So bias is where you just have a personal feeling about something that you cannot set aside and make a decision based on the standards and criteria and the evidence before you. And everyone has bias. Everyone has certain cases that they cannot review. And the reason why there are 7 of you, so we can spare a few, right? So if you feel like the substance of this application, who the applicant is, anything is going to interfere, cloud your ability to make a decision based on the standards and criteria, you just need to let staff know. and you will be excused from participating in that matter. And it's simple. You might be interested to know that the thresholds for actual bias are quite high because, as I said, you all live in a community and you're expected to know what goes on in a community. And you're supposed to care about this community and what happens in it. That's why you've been selected to do this important job. So it is not the case that if you have in the past expressed concern about a road going in a certain place, and then the road goes there, and then a development happens on that road, that you cannot consider an application for development on that road, right? Of course, you would have a feeling about that road. The point is, can you set aside your concerns about that road and make a decision based on the evidence that is provided? You can't have any actual conflict of interest. Conflict of interest has to do with pecuniary benefits or detriments that a person or their family member might suffer as a result of the application. So if your son mows the grass for the school that's seeking an addition, and if they don't get the addition, your son might get paid less or more. That is a pecuniary conflict of interest, and you would have to recuse yourself. Next slide, we're going to talk about public meetings and records requirements. You probably already know this, but as public officials, you have obligations with respect to the government ethics to comply with public meeting and public records rules. A public meeting is a quorum of a governing body that meets in a public hearing to discuss city business. And a governing body can't meet in private to decide or deliberate on a decision, unless an exception applies. And so the important thing about that is that's why we meet in City Hall. That's why it's recorded. That's why a Zoom option is available. All of this because this is a public meeting. You cannot have an email, if you have an email conversation with more than four of you, I think 4 is a quorum, without creating a public meeting. And a public meeting does not occur, even if it doesn't occur all at the same time. So if Commissioner A emails Commissioner B emails Commissioner C emails Commissioner D, public meeting. And I don't know if you've been paying close attention, but the Oregon Government Ethics Commission, which is the agency charged with ensuring compliance with public meetings law, has promulgated some rules and some frequently asked questions lately that has taken a much more stringent view of this serial meeting situation. This prohibition came about because of a lawsuit where one board of commissioner, Lane County Board of Commissioner wanted to know what the others thought before the meeting. And so he started a series of text messages and emails and said, "What do you think about disciplining this person?" And then he went to the other person. He said, "I talked to this person and they said this. What do you think about disciplining this person?" So there was an intentional effort to sort of suss out a collective approach outside of the public meeting, at the forum. So this question of intentionality and knowledge was part of this case that led to this serial meeting prohibition. What we're hearing from the Government Ethics Commission right now and some of the enforcement cases is that you can violate the serial meeting law or the public meetings law without knowing it. In other words, if Counselor A emails Counselor B and asks a question, and then A emails C, and then A emails D, that can create a CO meeting and B and C wouldn't know about it and D wouldn't know about it. They can unintentionally create a public meeting by just engaging with one other person rather than engaging with 4. And so there's a lot of confusion over that right now. And there are instances where we're seeing, there's an instance in Portland right now where less than a quorum got together, decided what they wanted to do, and one of them emailed a 5th person. And that 5th person didn't know that the 4 of them had already had a conversation. And that is now subject to investigation. So we want to be really careful with these communications.
How far reaching is that? I understand for land use and applications like that. I'm on a downtown commission too, and we're setting up the Oktoberfest. If 4 of us meet to talk about where to position vendors and things like that, would it still extend to that?
It would, because all of these city initiated committees and boards the members are public officials.
I thought that was the case, but I was just hoping not.
Yeah, no, I
Could
hear
I
ya.
ask a quick consequence question?
Yeah.
I'll go there. Aside from, obviously, bad optics, what are the penalties for that violation?
So it's a good question. The penalties run to the individual and they're financial. And they can be $1,000 per violation or a lot more.
Okay, thank you. That's helpful.
It's for real.
Yeah.
Does this work at the highest level of the state? Say with
Yes.
legislators and senators?
Yes.
So you're telling me that when they're whipping a vote and we have the Democratic majority, for instance, talking about said legislation, there's not a public meeting happening, not in public?
Well, it has to be quorum. Has to be quorum. So you have to have more than however many it would take.
But
That's what a whip is. Yeah.
The quorum's a pretty large.
is it a rules for?
It applies to all agencies. It applies to all public officials. So yes, it applies to the legislature too.
Could I ask a quick conflict of interest clarification? Since you're attorney, you're going to give me the best advice on this, just because it's been kind of great for me. So I'm employed by the Estacada School District.
Sure.
Frequently, the district, through various things, comes forward with plans. In terms of the definition of conflict, my family nor I benefit from a decision such as this, nor is my employment impacted. Is that still under the definition of conflict of interest if I were to participate in a planning commission decision on my employer's, I don't know, whatever, you know what I mean?
Yeah. So I don't think if your pay won't change, whether they get to build this addition or not, there is no conflict of interest. What I would recommend though, is when the time comes for the discussion of ex parte contacts, conflict of interest, bias at that time,
Yeah.
I would say I am employed by the school district, but I feel like I can make a decision based on the criteria, right? Because I think this goes more to bias than to conflict
Agreed.
of interest,
Yep.
right? Like you could want this because you work for the school district and it's a great thing. And
Right.
so I think it's important that you disclose, I do work for the school district.
Okay. Thank you. That's very helpful.
Okay, moving quickly along, public records. Public records are any writing, data storage, or other record relating to city business. And public records have to be maintained by the city, consistent with public record retention schedules. So when I come to a meeting as a participant and I submit materials, I give it to Evelyn, and Evelyn puts it in the record, and then it becomes a public record, and it stays in the city archives. If you receive emails those are also on city business. Those are also public records. And if you text somebody about city business, that is also a public record. And if the city were to receive a public records request for those emails or those text messages, the city would come to you and ask you to produce those. And so it is incumbent on you as a public official to do what you can to keep city business separate from personal business. Make an Outlook folder where you put it all. Try not to have emails with your fellow counselors that say, yes, at the next meeting, let's talk about the city's plan to extend this road. And then here's my wife's recipe for sourdough bread, right? Like, keep them separate. Like, send an email with the sourdough bread recipe for sure, but send it separately from the email that says, I will be at this event at this date, right? Just try to try to think about it as two different hats. You have your planning commissioner hat, and you have your individual person hat, and those try to keep that wall as much as you can. If you don't keep that wall and the city gets a public records request and you haven't separated these emails and you don't want to separate the emails, the city will go through your emails and separate them for you. And you probably don't want the city to read your emails. So try to keep it as separate as you can. The final point about public records is that the notes you take in a public hearing are public records. And it doesn't matter whether those notes have anything to do with city business. So if you're writing your shopping list or to-do list for tomorrow, that is a public record. I'm just telling you because there have been instances where city has received public records requests for notes taken during, the public sees you writing. As are social media posts done during public meetings. Okay, next issue, the final government ethics thing I want to say is you cannot use your public position to obtain any financial benefit. So you can't, I always see that, go up to the lemonade stand and when there's a long line and say, hey, I'm a planning commissioner. Can I get a quick lemonade? No, you can't. And a gift. A gift is anything of economic value and that is not offered to the general public, and the maximum total per calendar year is $50. Includes relatives, household, and businesses. And again, can result in personal liability for violations. The Government Ethics Office has a big website. They have all kinds of opportunities to ask questions. The city is available to assist you in all of these government ethics issues because they can get thorny. And so feel free to reach out with Elena, and she can put you in contact with the city attorney or whomever is the appropriate person. Okay, jumping back into land use. So here we are back in land use, and you've held your public hearing and you've taken evidence and you've heard from the applicant and you've heard from the public and opponents about their concerns. And then you've closed the public record, right? That means no more testimony, and you are deliberating to make a decision, right? This is why you get the big bucks, right? This is where what it all comes down to. And you have to determine whether the applicant has met its burden to show that the applicable standards and criteria are satisfied. The best way to do that is to make sure you interpret the applicable approval criteria. We talked about that, interpreting what the words in the code require. You have to identify the facts and evidence in the record that lead you to a conclusion that the criterion is satisfied. personal knowledge is not evidence in the record. So if you are an expert at, if you are a geologically trained expert and you've looked at the geologic study and you know it doesn't adequately address landslides, you need to say that while the record is open so that folks have an opportunity to respond. During deliberation, you can't say, well, I'm a geologic hazards expert and I can tell you that this has got a map landslide on it, right? Because then the other side nobody's had an opportunity to respond to that, what is new evidence.
Question on that procedurally. So we normally open with our staff report
Mhm.
and then we ask any questions. Is that the time to ask
Yeah.
or state that?
Yeah,
And then once we kind of settle everything out, we open the public hearing with our big
yeah,
verbiage here from the state or city, close it back down. And then at that point, we motion second and then discuss again based on everything we heard from public hearing and the,
yep. And you can discuss before you make a motion or you can discuss after you.
oh, we
make a motion.
can discuss before a motion.
Yeah, if you want to.
Okay.
Yeah.
Sorry, I
The,
derailed you a little bit there.
no, it's okay. And to follow up, let's say the testimony jogs for you something that you know about this particular property or an experience that you had that you think is relevant to this. If somebody testifies and says, I sit at this light for 5 minutes and you think that that's, and you have experienced that too, and you think that's relevant, you say, and I've experienced this too, that I've waited 5 minutes and the applicant's traffic study says it's 30 seconds. Again, if you expect to contribute evidence to this, not that you should, but if you want to, you've got to get it out while the record is open and folks have an opportunity to comment. You're scowling.
Well, we had an incident called Lawrence Road, and it was a subdivision that was putting more
Hey,
driveways.
Scott,
could
can you
you
get closer
speak
to
into
the
that?
mic?
Yeah.
More driveways onto a road that was in planning going to be a major collector of traffic, right? And I was part of what PepsiCo calls Starfleet, and everything I said is you don't back up vehicles because it's dangerous. But the applicant did everything correctly. I mean, their subdivision was flawless except for this one safety flaw, huge safety flaw as far as I was concerned. And we denied the application based on the safety flaw, but we were overruled by the council, and certainly they did everything correctly. And to the point was I started questioning myself, well, I didn't present it correctly, and I can see I didn't do that. Yeah.
Well, I think, I don't know what the circumstances were, but maybe the thing to do would be to come to the hearing when we do the disclosures and say, I've reviewed this application and I drive these trucks and I know what it takes to back them up. And I have significant concerns based on this experience. And then it is up to the applicant to show you that either truck drivers are better, trucks are more, the point is you got to get that out early. You can't say at the end during deliberation.
Sure. Yeah. Well, we run into these issues all the time. It seems that, part of us we're part of the city of Estacada and right across, and half the road is the city of Estacada and the other half is Clackamas County. And there's always that battle. Okay, what are we doing here? And, and we're always looking at that planning element all the time. And I'm saying, okay, down the trail, this is a really bad decision to do this, but but they did everything correctly. So, we're just forced into a bad decision.
Right. Well, and
Today it's still
you
bad.
can always, one of the things you can always make your code better. You always wish your code was better,
Sure.
right? Because when you write a code, you're not thinking of all of the circumstances that are going to come and test the bounds of that code.
Okay.
A little bit more on this particular one. Alan, correct me if I'm wrong. Wasn't there a change to that road designation that was coming down the pipe that we hadn't adopted yet?
Yeah, so the TSP was upgrading that road, Lawrence Road, but only, as Scott pointed out, only the city side, because it
Yeah.
was the western half was city
Mm-hmm.
under city jurisdiction, or within us, I'm sorry, within the
UGB.
UGB. Yes, within the UGB. So the UGB is on the center line of Lawrence Road. And then so the city was upgrading the designation of that road to a, I believe, major collector.
Yeah,
In order for the road to widen to a point that it would actually be more like a local road, because we only had jurisdiction over half of it. So it's kind of a wonky kind of
So in
solution
that
for that.
situation, we're bound by when this application comes in, we have to do it under those rules, not rules that we're probably going to adopt 6 months down the road, right?
Yep.
So kind of to his
The
point,
fixed
we're
goalpost rule.
we're damned if we do and damned if we don't. We're looking at it under today's lens, but we know in 6 months it's probably not the best decision.
yeah. But there's something I also found out too down the trail, and this was just experience with being on this commission, is that nothing is ever written in stone, especially when it's on a piece of paper. And, modifications can happen. And we've seen, many, many different subdivisions modify. And I said, well, they may come back at another time and say, okay, well, they started to comply with us and other projects they had going on, seeing that this was a problem for us. And that's good. I'm glad they did that, and they recognize that fact. I said, well, I know that at some point they may come back and modify that. And we have to look at that as well, and I go, it's not the best decision, but at some point we may see that same subdivision come back as this, yeah, we initially did this, but we can see that maybe that's not our best plan. And I'm going, yeah. And then at that point, we actually win, kind of de facto win in this thing, because these things drag out 10 years, and who knows, what was good today may not be good tomorrow. So it's interesting.
Okay, so, the deliberation, we've talked about how the evidence need to be based on the facts in the record. Where there is conflicting evidence, the commission should try to state why certain evidence is more reliable and entitled to greater weight, but ultimately, the planning commission gets to decide. You get to decide which evidence is more reliable. You get to decide which evidence gets more weight. There's often a conflict between what a traffic engineer puts together and what people's experience is with respect to traffic. Those often are different. And and a traffic engineer's job is to evaluate how many cars can get through an intersection, not how irritated you get waiting behind all those cars, right? And so what I've seen really works well in those kinds of conflicts is for a planning commissioner to acknowledge that difference, right? The standard might be traffic engineer determines that the roads are above a level of service C, or it may have that kind of engineering thresholds, right? And if it does, then how frustrated you get isn't part of the criteria. And it's, again, should the code be something different? Maybe, but that's not the criteria. But there often are some opportunities in discretionary reviews to think about, how frustrated you get waiting or how unsafe it is with cars backing and those sorts of things. There are opportunities in the criteria to address that. Decisions have to have adequate findings, which means there has to be a good explanation of how the evidence leads to the finding of compliance with the criterion. Many planning commissioners don't know this, but what goes to LUBA in the event of an appeal is the written decision. That's it. LUBA only looks at the written decision itself. So all the buildup, all the conversations that happened before that, irrelevant. It is the written decision and the written findings that explain that the criteria are satisfied. Planning staff can be really helpful with that, with the staff report. But if the planning commission is going to deviate markedly from the staff report, what needs to happen is you need a tentative decision. You need to give the planning staff opportunity to revise the decision. And so you have a complete decision that the planning commission is happy with. Decisions can be supported by conditions of approval. Those are things that an applicant has to do in order to ensure that the standards are met. Staff can help work with you on those. Next slide. There are limits on what the extent of the conditions of approval that the city can impose. These are set by the Fifth Amendment. And they mostly pertain to the fact that the city can't demand something that is not proportional to the impact of the development proposed. So if I propose to build a house, the city can't put a condition on there that I build a library next door. Right? Because the library is not a direct, is not necessary as a result of my proposal to build a house. This idea of rough proportionality between the condition and the development is really important. And it has to be explained in the findings. And so these are often things where the city requires an applicant as part of a subdivision to install a 30-inch pipe, and this development only needs a 10-inch pipe. And so the condition requires installation of the 30-inch pipe, but provides for reimbursement by the city for the additional costs associated with the 30-inch pipe. And
So
that
we
can-
can't ask a new subdivision to build a school.
you could ask a subdivision to contribute some proportionate share to a school,
Okay. Awesome.
That's what SDCs are for.
Yes.
but that's also what SDC, I don't know, you probably don't have education SDCs, but
We do.
oh, okay, cool. That's a great idea. So anyway, so there are limits to this idea, to these conditions, but they can be a useful tool. I'm gonna quickly jump into the new legislation in the remaining 5 minutes I have left. Has been on the books for a long time, a obligation that when local governments review applications for housing, the standards and conditions and procedures that the city uses to review an application for housing have to be clear and objective. Clear and objectives are quantifiable standards. These are standards that do not require the exercise of discretion. This has been on the books for a long time. Originally, we thought it only applied to needed housing, which was like affordable housing and not all housing. The legislature made it clear in 8 years ago that it applied to all housing. So the cities have been working diligently to amend their codes to ensure that all applications for housing are clear and objective. This clear and objective theme has been running through all the legislation that has come from the legislature with respect to housing in the last 8 years. So the state is expanding the circumstances in which the city can only apply clear and objective standards. And the reason why they want clear and objective standards is that removing discretion makes the process more predictable and efficient.
On clear and objective, I noticed in this House bills they did that they changed cottages and apartments and one of them to be from 900 square foot to be saying a small footprint. Doesn't that go in the opposite direction of clear?
Well, they're going to implement rules to decide what small footprint is. So that is yet to be determined, but yes, you are right. And what's important, the point you're making, which is absolutely true, the legislature's decisions, codes, the legislation does not have to be clear and objective, but ours does. With that background, we have, so the city's code has to be clear and objective with respect to housing. And so that's why we have all of these, buildings have to be 35 feet tall. They have to be set back 35 feet. They have to have 60% transparency measured from the front. There's no discretion in this evaluation. So not so that was the world we were living in until 2024. We get Senate Bill 1537, next slide, which not only requires clear and objective things, but requires mandatory adjustments to those clear and objective things. So there is a list of items that where a housing applicant cannot satisfy our clear and objective standards, they are entitled to a greater reduction in those obligations. And so they get a 10% reduction in rear and side setback. They get a 25% reduction in landscaping. They get a 10% adjustment in the minimum lot size and building coverage. They get additional base zone height and additional one story. They get to avoid any prohibition on ground floor residential for mixed use. So this means an applicant, and the list goes on. There's about 15 of these exemptions. And so what happens is an applicant says, I'm building housing, I need this mandatory adjustment, and the city has to grant it.
Based on state law.
And there is no right to, the only person who can appeal that decision is an applicant.
Okay, should I even talk about it?
Which one? Go.
The one across the street here, the 99 units.
Oh,
It's hung up. We approved it, what, 18 months ago?
sure.
Something like
Are we talking about Estacada Lake Apartments?
Yes.
Okay.
So it's in limbo for whatever reason. I don't know personally. But the big hang up was the ground floor residential. I can't speak to you, I'm sorry. So they can just say, Senate Bill 1537, we're doing it. And
So my understanding is that the Eastlake Apartments was reviewed before the city amended the code to require ground floor commercial. So it didn't apply at the time the application was approved. But let's say they applied today. They could seek an adjustment under Senate Bill 1537 to the obligation to provide ground floor commercial, and they wouldn't have to. The caveat I should add, it's not all ground floor commercial. It's ground floor commercial except for the first 20 feet that faces a street. So there is some ground floor commercial. It's just not obligation, but it's not the entire floors. But your statement is correct. If Eastlake or Estacada Lake filed today, they could use this.
Okay, so one other question. And this jumps into fire code. So I know in City Corvallis for a long time had a 5 or 7 story building limitation because their ladder truck would only reach said height. I think it was 7. Anyway, because now they can 20% increase in the base zone height or 1 story. So they can go 8 stories conceivably. Do they have to do anything to provide the fire department an 8-story ladder truck?
So no, they don't have to provide the fire department a ladder truck, but I'm fairly confident that 1537 says that it doesn't waive any fire code. And so if this was a fire code obligation, then the adjustment would not apply.
Okay.
But if it wasn't a fire code issue, I mean, if it wasn't stated in the fire code, then yes, they would get 8 stories.
Interesting.
That kind of throws out everything, you've done out the window, because if you can just kind of do whatever you want to out here.
Scott.
What happens to the cemetery?
To the microphone.
Sorry. It just kind of throws the cemetery. What am I trying to say here? I see this thing as, you're building something fairly consistent throughout the city, right? And then all of a sudden you jump into this and everything changes and your whole cemetery just kind of goes to hell. Yeah.
I think the idea is that by only adjusting it by 25% or 10% or a few feet or 1 story, that it doesn't all go to hell. But I think that's a, matter of perspective.
Yeah.
If they can do a 10% reduction in setbacks in my neighborhood and to go an extra story high, that's gonna be a pretty major, to have a house that's now 3 or 4
Well,
stories.
yeah.
And so this is a done deal.
Yeah, this passed in 2024.
Okay,
There are
Wow.
very many states like, their cities are reducing, like we allow 35-foot residential building, knocking it down to 25 to take into account to this. Is that appropriate or?
Um, it could be done. You know, I think it would depend on how many of these you've seen. I mean, this has been the law for a year. How many have you received?
0.
So I don't know how, so one of the questions is, should local governments put these in their code, right? To make people aware, pros and cons to that. But they exist. So, you know, this has been law for a little over a year, and I have seen one in my practice, in my sphere of all the cities.
Sure.
So, you know, it's
Okay.
not like this is just everybody's doing it.
Well,
Not well.
the problem is that we're kind of unique in this period in time where if you look out there, we've got massive developments going on all over the place out here, you know. And all of a sudden, everything that's currently planned could just get thrown out the window and, you know, they'd probably have to come back and modify all their plans and stuff like that, but they simply could do that. I've seen modifications come across that spoke to all this. you know.
Right. I mean, I think it's new development, big new subdivision development that you're gonna see this stuff because it's developers who are sophisticated to know that this opportunity is available.
Would it apply to ADUs too then? So I
Uh-huh.
extra story on the ADU.
Next slide. I know we're 5 minutes over. I'm really gonna keep this to 2 more minutes. Senate Bill 974, is the even more recent, significant adjustment. First, it provides for a shot clock for engineering review. So after you get a land use approval, you have to go through and submit the building permits and the engineering plans and the public works plans necessary to proceed with your development. As it stands right now, there is no timeline for when the city has to process that. This bill creates a 120-day deadline for this review. Doesn't have anything to do with your work specifically, but just to know that that is the case. More important to what you do, this bill requires cities to waive standards intended to preserve the desired character as architectural expression, decoration, and aesthetic quality of new homes. For developments that have more than 20 single-family houses, and for really super tiny multifamily development. And so if you have a development of more than 20 single-family houses, it's a complete waiver of these design and development standards that affect these houses. So this is not the 10%, 25% that we were talking about before. This is none. If you have requirements about ground floor commercial, goes away. And requirements about materials, requirements about roof lines, requirements about orientation. Like many have orientation requirements that say a house has to face the street. Doesn't have to face the street. Garage location. Many codes have tried to push garages to alleys or push garages to behind houses or under houses or behind the front door. Those go away. The good part about 974 and this waiver is that this bill only stays in effect and will be automatically repealed in 7 years. So, our loss of character and control will only exist for 7 years, but it is potentially much more affecting.
Had to build a structure 7 years is nothing compared to the 100-year life of the building, so.
Sure. The thing about 974 does keep setbacks and it does keep height. So that is something. Okay, the last slide I want to talk about is House Bill 2138. The governor has been working really hard on encouraging middle housing. You all know what middle housing is, right? Okay, middle housing is more than one housing unit on what would be a single family lot. So it's a duplex, just 2 units with a shared wall. Triplex, 3 units with a shared wall. Fourplex, 4 units with a shared wall or without a shared wall. And those are, we call it middle housing because it's not an apartment building and it's not a single family residence. Slowly the laws have changed to require that the city approve certain types of middle housing depending on the size of the city. I believe Estacada is duplexes, or is it more than duplexes? It's duplexes. Any single family lot in Estacada has to allow a duplex. There had been some confusion about when traffic studies or offsite exactions, that means build a pipe off the subject property, could be required. And this House Bill 2138 says no traffic study and no offsite exactions for 12 or fewer middle housing units. So if you've got one single family lot and they're building a duplex, no traffic study or no obligation to fix a pipe across the way. You get additional middle housing unit type if you've got accessible or affordable units in your middle housing proposal. So if you've got a duplex and you've got one that is affordable or a certain level of ADA accessibility, you get a triplex or a fourplex, depending. You get in multifamily zones that allow 5 or more units, there's a whole bunch of additional density and parking allowed for single room occupancy type uses. And single room occupancies are like dorms where you have multiple rooms with shared kitchens and bathrooms. I don't know if that's a product that would resonate in Estacada, but if it does, you could have much bigger single room occupancy than you would otherwise in your multifamily zones. This is an important one. Some subdivisions have covenants that prohibit middle housing as private covenants. CC&Rs might have often have provisions that prohibit the further subdividing of existing single family residential lots. And it has been the law for the last couple of years that new CC&Rs could not impose that restriction. What's important about House Bill 23 is that it voids all pre-existing ones. This is not germane to the work the Planning Commission does, but you might sometimes hear people come in and say, or you might hear complaints about this. So that's what the law says. Again, the city's land use review does not review the validity of CC&Rs. Those are private arrangements, but I just wanted you to know that's the law. Tree codes have to be clear and objective, and middle housing land divisions have to be processed more quickly. That will be probably something for staff. My final slide is recommendations for effective participation, and you can take a look at these on your own. 2 sort of pieces of advice. Anything you can do to review applications ahead of time and form questions ahead of time will make for a much more productive and useful meeting. If you have questions and you ask them to staff ahead of time, a conversation with staff is not an ex parte contact. Ask them, learn about it, hear their thoughts. Make the time of the public hearing as productive as you can by being prepared. And then be confident and express your mind, and don't be afraid to disagree. The reason why you have been chosen and why there are 7 of you is because you all have different thoughts and experiences that come to bear in this process. So be willing to disagree, because that's what makes for a thoughtful decision. So thank you. I took a lot more time than I had hoped, but I had a lot more to cover. So I hope that this was helpful. Feel free to give your feedback to Ellen or to Elena and, thank you.
Thank you.
Thanks
Thank
for
you,
coming.
Jared.
I thank you so
Thanks.
much. Very
Thank you
informative.
so much. Super helpful.
And I will get this, Melanie will get this out or Elena will get this out to you.
Thank you.
Good.
Okay? All right.
All right, here we go.
I would like to take a 3-minute bio break. Okay,
Sure.
thank you.
Do I need to smack the gavel? I did anyway.
Off the record.
Interesting.
Okay, ready to rock and roll again? We'll go ahead and call the meeting back into session here at what are we, 12:27? We have one public hearing to go over. Ordinance 2025-008 Title 16 Development Code Amendments. Alan, if you want to
Alright.
present our staff report, that'd be
You
awesome.
guys ready? Yep. All right, so I will present my staff report for this ordinance 2025-008, which concerns amendments to sign code regulations. Okay, so first off, just to give you all some background. So by early this year, we had recognized that the city's code regulations regarding signage is often difficult for applicants to interpret and for us to apply and enforce for a variety of reasons, including format is complicated, definitions and standards are unclear at times, and various other shortcomings. So then in April 2025, the council directed staff to draft revisions to the sign code language with the aim of simplifying and clarifying the existing regulations. So this is less of a policy change and these are more kind of administrative organizational changes. So then in June of this year, we proposed a new organizational structure for the main sign code chapter, that's 16.72. And we also proposed the addition of supplemental visual materials, which includes some pictures of flags, or I'm sorry, pictures of signs, including flags, figures, and a sign types and allowances table, which is included in the draft amendments. Also in that June meeting, council directed staff to draft the proposed code amendments and the supplementary materials. And so ordinance 2025-008 comprises those amendments and materials. So in a nutshell, this ordinance would enact the following code revisions. So we've drafted a full reorganization of the sign code chapter. We propose to amend sign standards and references in 8 other municipal code chapters. The amendments clarify and expand definitions related to signage. Contradictory, needless, and legally indefensible language has we've tried to delete as much of that as possible. We're going to add pictures of sign types. That's actually underway right now. We're collecting photographs in these coming weeks. We've removed as much content-based language as we could, and some minor policies were altered as requested by council in public hearings. All right. And so in order for the council to adopt this ordinance, which involves amending the city's development code, Title 16, all relevant approval criteria must be met. And so relevant approval criteria in this case includes the Oregon statewide planning goals, Estacadas comprehensive plan goals, and chapter 16.128 of the municipal code. So we'll start with that, with the development code section. So there are 4 sections in this chapter, and here's the first. So legislative amendments may be initiated only by planning commission or city council. And these amendments were initiated by the council, so this criterion is met. And the second is, so this is just about the procedure for amendments. The planning commission makes a recommendation to city council upon completion of a public hearing. That's what we're doing right now. And then the planning commission and council will adopt findings to establish that the amendment will not conflict with provisions of the development code or the comprehensive plan. And then the legislative amendment may be made by council after planning commission's recommendation and after a public hearing. And those criteria will be met. Let's see. So the third part here is the findings shall be made in writing and shall be made public. This is basically just the, point by point, what's in the staff report, and then what will go into the planning commission report recommendation, and then what will go into the council decision. Those findings shall also be consistent and in conformance with applicable regulations of the Estacada Municipal Code and the comp plan. And those criteria will be met. And then no limitation for an amendment to the development code shall be considered by planning commission within one year period immediately following a previous denial of a request. So no similar amendment has been proposed and then denied in this last year. And so this criterion is met. So now we'll move on to discussing the statewide planning goals and the comp plan goals. Okay, so the city sent published information about this hearing to the local paper. And on the city website, sent notice to the state planning agency, DLCD, and is following all other pertinent land use laws related to public hearings. So these 2 pair of procedural goals have been met or are currently being met. So here's a list of all the statewide and city and comp plan goals that do not apply to this ordinance. So you can see that it's most of them. But there is one comp plan chapter that does apply to these amendments, and that's chapter 7 on economic development. And specifically one policy applies here, and that's downtown policy 6. And that reads, the goal is to, or the policy is to implement designs, guidelines, and standards. I'll just skip ahead to regulations for signs that require pedestrian scale, pedestrian-oriented signage while prohibiting large-oriented signage. And so by clarifying the existing sign code regulations that require pedestrian scaled and oriented signage and prohibiting some large forms of auto-oriented signage, this ordinance supports downtown policy 6. And so staff finds that these amendments are consistent with chapter 7 of the comp plan, and staff is recommending approval of this ordinance without any conditions of approval. And now I am hopefully prepared to take your questions. After that, we can hear from public if any would like to provide testimony. A planning commission can discuss, and then we will be looking for a decision. So that includes a motion to recommend approval, approval with conditions, or denial of findings.
I got a question here.
Yeah. First question I have,
Yep.
1672-050.
Okay.
Section A, flashing or moving signs. You have flashing signs out there right now. 25 mph with white border, flashing white border.
Oh, okay.
Would we be prohibiting that particular thing?
So if you're talking about the highway, that's under ODOT jurisdiction, and there is
No, that's on Eagle Creek.
oh, it's on Eagle Creek.
Yeah, it's on Eagle Creek, yeah.
Interesting. Well, that is something to look at.
You're talking about the flashing
Yeah, the little flashing 25
Yeah.
mph signs.
Right, right,
Yeah, it comes at both sides of Eagle Creek. That kind of borders Wade Creek, a lot of kids, a lot of people walking around there. So that makes sense there to do,
Yeah, I'm glad you brought that up, because so if you look at the section before it, which is the exempted signs. So that would be 1672.040. If you look under B, it exempts directional warning or information signs are structured, required, or authorized by law or by federal, state, county, or city authority. So I think that maybe what we should do is rewrite or add to 1672.050 the flashing sign prohibition. Could say flashing signs except as exempted by the code section that I just read.
Sure.
Good find.
I have one, same thing, 050 prohibited signs.
Mhm.
I guess first one, school district has pretty large signs in front of their locations that flash, move. Some of those, would those somehow be grandfathered in to determine? 'Cause those are all informational type signs.
Right, yeah, that's interesting. So, yeah, they're directional warning information signs. Yeah, I'm not sure if the school district if those would be considered required or authorized by law. Those are, I guess, design choices for the sign that the school district made.
Right. Okay, that would just be one I would be concerned about. And
Yeah,
then
yeah.
more for humor's sake, but also a dream, where it's pole signs in the riverfront commercial, highway commercial. Where's my big Taco Bell sign? How does that fit in there?
Oh, wait, where are we?
Same thing, 050, prohibited signs, letter I.
Mine is showing billboards. Are we looking at the,
Let's see, page 14 of 23. The prohibited sign section. I'm interpreting letter I pole signs.
oh, okay.
Being
I
the
think I have
big,
a slightly different,
oh, sure.
Thank you. Yeah, maybe I should read
Yep.
about this.
I just, when we put in our Taco Bell or Safeway or bowling alley or whatever,
Whatever shows up there.
yeah. Our 30-foot Taco Bell pole sign that people can see from the highway.
Oh my
Is
God.
Right,
Would they be able to go through a permitting process for that, or?
Let's look at the definition of pole sign. I want to make sure that what we're talking about isn't a freestanding sign. So pole sign is a type of freestanding sign, but I don't know that all pole signs or all freestanding signs over 8 feet are comprise all freestanding signs. Let me look.
Okay.
Pole sign. A single or multiple face sign 8 or more feet above grade, supported by one or more uprights in the ground and detached from any building or structure. So to me, a pole sign is basically, it's a little bit different than what you're describing,
Okay,
but we want to be clear about that in the code.
yeah.
So I'm really glad that you guys are bringing these up
What
because.
would you describe Sol Tapatio's sign as across the street?
That's great
Right, yeah.
example.
So. Yeah, ground sign's nothing higher than 8. Pole sign is higher than 8. But I don't know that like, when I think of a pole sign, I think of literally poles holding it up. And I think that would be a freestanding sign that is not a pole sign.
Okay,
But I'm also gonna say, I don't think that the code is super clear on that right now. So I'm going to make a note so that we can clarify that. Okay, thanks.
Those are all my questions.
I have a couple of questions.
Go ahead, Tara.
I'm wondering, on the exempted section, why political signs are exempted? Like, what does that mean? Does it mean just like the little political yard signs, or does it mean the big giant political signs? And how does that fit with the other discussion we had about that like almost a year ago or whenever the heck that was? Yeah, why are those exempted? What does that mean? And then my other question is, why are things attached to shipping containers or other stationary objects? What does that exemption mean? And could I make a sign that violates everything, but as long as I stick it on a shipping container, it's then okay? Like that's just seemed a little confusing to me.
Yeah, okay. Well, I will address your first question first. So I've been working with Carrie, who just gave the land use presentation. I've been working with her to remove as much content-based standards as we can, because they are not they're not really legally defensible. You can't tell people what to put on the sign generally. Like if they want to challenge it, yeah, you can regulate time, place, and manner of signage, but you can't say like, you can't post a political message on a sign. You can say you can, temporary signs of this size and type are allowed in this zone for 6 months, but you can't say you can't put a political message on that sign.
Sure, but what you're saying is you can do whatever you want as long as it is a political sign, which seems content-based.
Yeah, that's a tricky one. I mean, I guess what we're trying to say is that we are not going to regulate political messaging in the city.
But that would need to be said differently, because we're regulating all signs. Why should a political sign be regulated any differently? If we don't care about content, why is a political sign regulated differently than
Well, that's
a
what it's
burger
not
barn
regulated.
sign?
It's exempted from regulation.
Right, so that's a different regulation than any other sign, because other signs are not exempted. So that's treating political stuff differently.
I'm going to talk to Carrie about this. I think she has more perspective, or I think a better answer for this. But yes, I'm going to highlight this. And actually, Tara, can I follow up with, I can follow up with everyone on all of these, actually.
That'd be great.
Okay. Your second question, do you mind if we move on to the second?
No, go
question?
ahead. Yeah.
Okay, thanks. So let's go to that. That was on exempted also. Signage on structures intended for separate use, into phone booths and goodwill containers. This is intended for if you have like imagine an old phone booth and it has basically just a sign in it that says like Pac Bell or something like that. That's the kind of signage that we're talking about. Or goodwill container that says Goodwill on the side of it. So that's the intended for a separate use, intended for the use that the structure is serving is maybe a better way to say that. Does that make sense? It's not.
It does,
for,
yeah,
like, if you're on a phone, you can put anything you want on a phone booth. We're not gonna regulate that. It's more just like the signage that comes with the structure is not subject to sign code regulation.
Okay, yeah, I mean, it came to mind because the highway on the way to Estacada is full of big, truck containers and shipping containers that are like abandoned and falling apart, but have various signs on them. And I don't know if the reason those are attached to those items is because there's a similar exemption in county or highway, whatever signage legislation. So I was curious if like those kinds of things would be, if somebody could literally just put whatever they want on a
Right.
shipping
Are you talking
container
about
and pop
outside
it
of city
somewhere.
limits?
Yeah.
Okay.
Yeah.
Okay.
Is this intended to allow similar exemptions.
No, this wasn't an addition. This is just what's been in the code. This was just copied. It's just, the reason it's green is because it was just lifted entirely from another section and put here. That's part of the reorganization. Yeah, so not everything that's in green is a new. Actually, most of it is not new.
Okay.
But I think that this standard could be written a little bit better. So I'm going to look into that as well to see if we can kind of clarify what I just explained.
Could I ask about just monitoring and enforcement? And again, just to be
Sure.
mindful of city staff.
Yeah.
You know, if I walk up to a telephone pole and I double staple yard sale this Saturday, that would be out of compliance, correct, for that? And so the
yeah.
expectation would be as city staff drives around and they notice that, they would just remove that.
I believe so. I believe Amy is doing that. Have you talked to Amy about that? I mean, yeah, it's in the code that you can't post on telephone poles and such.
Yeah, I believe Amy, if she sees that, she takes it down.
Okay, sounds good.
And-
And that's
yeah.
a realistic added expectation of
Well, that's
city
the
staff.
existing.
Oh, that,
yeah.
that's currently, okay,
Yeah,
okay,
yeah,
that,
yeah,
that's helpful.
Yeah.
And then
yeah.
just one hypothetical, if in the next presidential election, if someone were to double staple a political sign on a telephone pole, that would be allowed because political signs are exempted?
No. So this is where we might want to, we should probably tighten this up. So like I said, the city can regulate time, place, and manner.
Okay,
So place, no signs can go on telephone poles. So regardless of the content, no sign would be,
okay,
yeah. So, yeah, I think it will be important to clarify that.
okay.
Yeah,
Thank
so I
you. Yeah,
appreciate these hypotheticals and
yeah,
the questions. It's good.
On page 1723, they crossed out allowed time frame. Political signs may not be posted more than 60 days. And they must be removed. My concern there is that, is there another place where if I put up a sign, whether it's for a yard sale or political sign or anything, then I have to take it down? Because this looks like it removes that. And I hate to see signs, just all people abandon them basically months later.
Right, so according to time, place, and manner, most political signs are temporary signs. So there's a section that regulates temporary signs. And that describes an allowed time frame may not be posted for more than 6 months in any calendar year. So that would just apply to any temporary sign,
It's a
of
long
which
time.
political signs usually are. I mean, but if someone wanted to, go through the permit process and put a monument, like a ground sign in their yard that had a political message in it, then the city wouldn't stop them from doing that. Yeah. Any other questions?
no, just a final comment on my Taco Bell humorous joke. I don't want to create anything that is prohibitive of economic development franchise from coming into our community.
Yeah,
And
that
I-
makes sense.
Yeah,
Yeah, and I mean, that comment's very helpful because I don't think that it's especially clear at the way that the code is written now, that would not be a pole sign.
cool. Yeah,
And I think that we can make that clear.
okay, thank
Yeah,
you.
thanks.
Any other questions? I have a question for
Yeah.
the counselor for the room. Being that some of these things are unknown at this point in time, is there a sense of urgency on this that we have to have this done at this meeting? If it,
No, I don't believe, I mean, I think council would like to get it done. It's been, I think we first spoke, yeah, well, like I discussed, April was when we came to council with that. And then we proposed the reorganization and the new materials in June. I don't think that this is like a burning issue. If planning commission would like to continue this to the next hearing, that is possible.
I'm just wondering if at that point in time, we have pictures in here, because there's a
Yeah.
spot for the pictures.
Yep.
And we could go, okay, this is a pole sign, this is a sandwich board, this is
Yep.
a,
So the deadline for pictures, we're actually, I'll just explain, we're doing a scavenger hunt with staff.
Fine.
So just to avoid using pictures that might risk copyright infringement, we're generating all the pictures ourselves. And so that's just gonna take a little bit of time. We've enlisted staff. It's like we're doing a little fun contest. Yeah, so the deadline is October 3rd. Is that right?
The third or the second?
Something like that. Yeah, the
Yeah.
beginning of October was the deadline. So that we could include all the pictures in the adoption packet for council. So council is slated to consider this on October 13th. We could move that. That's not a problem. If planning commission felt strongly about reconsidering this on the 8th, at the next planning commission meeting on the 8th, then we could do that. And pictures would be included by that point.
I mean, I can only speak for myself, but I support the concept
Sure.
entirely. But
Yeah, yeah.
I would like to see the revisions and the definitions. I think that would be helpful
Okay.
to us.
Yeah.
Yeah, I'd agree with that. It'd be hard to vote on this right now.
so then as far as, do we need to have a public hearing still at this point in time, or are we just continuing it? We'll have a public hearing with our next meeting.
I don't know what the actual process is for that.
Well, here for conversation's sake, let's just, if it's okay, we'll have a public hearing now.
Okay, yeah, you can do that. And I think that the motion can be to continue the hearing.
Okay. All right. So right at this point in time, we've heard the staff report. We'll exit out of the planning commission meeting and we'll go into the public hearing and ask the audience, anybody online, if they have any comments on this. If you do have any comments, we'll ask you to step to the mic and introduce yourself and your address. So at this point, it doesn't look like we have anybody in the audience for sure. Is there anybody online that doesn't belong? Okay. So then we'll exit out of the public hearing. I need to ask the commission if there's any buddy that wants to abstain or declare ex parte contact on this matter. Okay, doesn't look like there's any ex parte contact. Then we would ask for a motion to approve this with conditions, deny it, or we could do a continuation like we talked about in our first discussion.
Exactly, yeah.
I move that we continue this on to the next meeting.
Do we have a motion for that?
I'll second the motion.
Got a couple seconds. Do we need to discuss that part any? I think we've already done it. Okay. So all those in favor of continuing this to our next scheduled planning commission meeting on the 8th of October, is that correct? Is that the right date?
Yes.
Okay, raise your right hand.
Yes.
All right, so we're just gonna continue this and pick up with a little more information on the 8th then.
Great. Thank you all for your feedback. It's really helpful. I mean, as you probably noticed, it's pretty meticulous and
Yeah.
it's hard to think of all the scenarios that could
There's a
come
lot
up.
of
But
what
really, like getting everyone's head together really helps.
Yeah.
So
Well, and your hard work is noted in this as
well,
well
I
too.
appreciate
so
that. Thank you. Thanks.
Yep.
I like seeing all the red strike throughs on any of this code stuff. It knows that we're cleaning it up, so.
Yep.
Okay, so where's the rest of the agenda? Oops. Sorry, guys. Looks like we have public comment. We have none. Any commission comments?
I would like to just say one thing. I'd like to recognize Commissioner Stahl, because he's a humble person. But Commissioner Stahl, representing us, had the opportunity to participate in several elite competition bike races in Europe the last couple of weeks, and his goal was to finish in the top 10 in one of those races, and he finished in the top 10 in all 6 of his races, both in England,
Wow.
France, and in Belgium, and he won the very first one outright in first place. So I just want to say congratulations to you, and what a cool story, and I wanted to just highlight that because I think that deserves recognition.
Yeah, that's awesome.
I thank you and I'm glad it's over with.
Wow.
Yeah, that's really cool.
All right, well, if there's nothing else, let's go ahead and adjourn at 12:54. Thanks,
Thanks,
everybody.
everyone.
Thanks, Sarah.